To speak on this, I'm joined now by Vikas Singh, former ASG, who's joining us on the show, and former top lawyer. Arjun Sharun, advocate, is also joining us on the show. Welcome to both of you, and thank you for speaking with us on Beyond the Headlines, where the idea is to educate and inform the viewers of what the facts and the story is really about. Mr. Singh, let me begin with you by trying to understand why this case has gained momentum now. I'm trying to understand the timing. We mentioned in our opening report that the case legally dates back to 1991. What is the current trigger for these new spate of petitions in courts?
Well, there was a petition filed in the Supreme Court challenging this Places of Worship Act in 2020, and the Supreme Court has issued notice. Now, the ground for challenge in that petition is very, very serious, because the petition states, and I agree with this, reasoning, that pilgrimages to outside India is a central subject, and all pilgrimages within India is a state subject. Ancient monuments which are declared by law of national importance are central subjects, and other monuments are state subject. So really, whether the Narasimha Rao government had the legislative competence in 1991 to frame a central law to control the religious, pilgrimage places or places of religious character is a very, very debatable question. Now, unfortunately, nobody has challenged this law till date. And you can appreciate that in 1991, the regime used to be...
I'm going to come to Places of Worship Act in a bit. Mr. Singh, I'm going to come to Places of Worship Act in a bit. But I think it's important to set the context for our viewers. Like I mentioned, the purpose of doing this is to explain to people what really is going on right now, so that they're educated about what the story is today. So my question to you, and I will reiterate it, is why are all of these cases coming up now?
Well, that could be a political, reason. I can't comment on that, because I really can't. That is a factual narrative that you're wanting me to reply to. I can only tell you the legal narrative and whether there is any case made out for striking down this act, and whether a suit can continue till the act remains in it. So according to me, till the act is not struck down, a suit cannot proceed. A suit should be rejected under Order 7, Rule 11, as without any cause of action. Okay. So till there is no stay of the act today. So as of today, there can't be any suit continuing. And I'm surprised how the Supreme Court permitted whatever it permitted as far as the survey, etc. is concerned, because that all will have to be sanctioned by law. And if the law says that there can't be any conversion, then what is the purpose of doing this survey? So there is a contradiction in the law as it exists today and the way the suit is proceeding, notwithstanding the law. So that is a separate issue. I can't comment on that, because who are behind this suit and whether it is rightly timed or not timed, or whether there is any political narrative.
I'm not going into that either, but I get your point.
Like a Hajj.
No, I get your point.
Like the Hajj pilgrimage, when the central government organizes that is something which is within the jurisdiction of the central government.
Yeah, but these are individual petitioners.
These
are individual petitioners. Yes, these are individual petitioners who have now asked for the right to pray. I'm talking about the current case, which is in the trial court and then has, been challenged in the Supreme Court. Let me come to you, Arjun Sharun, with that question, because I think it's important to set the context before we move further into why this case is important and where it could go, etc. Talk to me about the current case and its importance right now, and we will come to 1991 in a bit.
Tamanna, let me just say this. All these new cases are controversies which are being started for, the BJP government, and the Sangh Parivar is essentially planning for the next 30, 40 years. They planned the Ram Janmabhoomi in the 80s, and they got in 2014.
Mr. Sharun, we're sticking to the facts and the law. We have no way of knowing whether these petitioners are politically motivated or not. In the eyes of the law today, there are 5 women who say we want to pray.
It's not as simple, Tamanna ji. It's very... every petitioner who files a petition, for example, my friend Mr. Vikas Singh's client, Ashwani Kumar, he's also innocuously filed a petition challenging the 1991 Act. on paper, he's just a common man, but we know he's a BJP person. He's a BJP spokesperson. And he has filed, this is essentially a proxy interest litigation that was filed challenging the act and it was issued. And another leader of the BJP, Mr. Subramaniam Swamy, also filed it. Essentially, what they're trying to do is raise issues, and it doesn't matter which community. What they're trying to do is instill conflict in society.
No, there is a reason that I wanted to invite legal experts on the show today. And there is a reason that I haven't, invited politicians or people who claim to represent different religions.
Absolutely.
You represent the law. So let's talk about the law. Let me come to the next part. I'll come to Arjun and then Mr. Vikas Singh. What are you expecting the law to clarify in this particular case? We're talking about the case right now. So we've talked about the sequence of events over the last 24 to 48 hours, including the alleged discovery of a Hindu religious symbol, the Shivling, then the sealing, etc., and what the Supreme Court has said today. It will continue hearing the case. What will the law clarify in this instance? And is it an inevitability that it comes down to the 1991 Places of Worship Act, as Mr. Vikas Singh has said right in the beginning?
In fact, I hope it comes down to the 91 Act and it doesn't open another can of worms, because ultimately what you would do is, if you don't do that, then in every street, every gully and mahalla, you will be starting another dispute. And I say this as a lawyer, because there is a reason why the 1991 Act was passed. There's a reason why the Babri Masjid judgment, the 5-judge bench in the M. Sadiq case, they said it's almost part of the basic structure. They said you have to put the past behind. You can't keep going back to the past. And they say non-retrogression is a foundational feature of the fundamental constitutional principle, of which secularism is a basic feature. So the court is very clear. The constitution is very clear. No Tom, Dick and Harry can get up today and keep raising these issues in an independent India. We are going towards a new India as per the current government. Very well. Let us leave that behind. Okay. And the 1991 Act is a constitutionally valid act. The aim of the act is to take us forward and not leave us behind in the 18th or 11th century, as many people want to go. And just as a lawyer, I have gone through the act. I've gone through the petition Mr. Vikas Singh's client filed. Unfortunately, all they're trying to do is, this is a very essential legal act which stops conflicts from happening every single day.
Mr. Vikas Singh, then let's now come down to the 1991 Act, because it seems to boil down to that. It's your take that this case is, not really going to go anywhere until the 1991 Places of Worship Act is modified in some form or fashion. Why do you think that's necessary? And what would you say to some of the fears that, Mr. Arjun Sheoran has also talked about, that this will open up a Pandora's box?
Well, I don't agree that this will open up a Pandora's box. If you ask me, if you ask my personal view, this 91 Act was completely, according to me, ill-conceived. If you are only thinking of communal harmony, then there are other ways to maintain communal harmony. If there is a petition to be decided in law as to whether there was something there which was converted later on, because if you go on Wikipedia, it says even the name Gyanvapi itself suggests that it's a Hindu kind of a name. So there was something which had to do with the Hindu people and the Hindu religion, and that has been converted. So I don't understand why in 1991 you could pass a law where you exempt Babri Masjid and say the others will not be converted. So that is a purely political call which was taken. But I am on a more fundamental issue. Whether the parliament had the authority under the constitution to pass this law at all. And that's the point that I'm making. If they didn't have the authority, then the law is without jurisdiction. If it is without jurisdiction, then it has to go. So then UP will have to either enact a similar law or not enact a similar law. If it doesn't, then all these suits will have to be revived. And wherever these suits have, been kept aback or not proceeded with, will have to be looked into. And I don't see that if the court process is used in a determination of any right, or finding out whether there was actually a temple here before the mosque was created, would create communal harmony. Even in the Babri Masjid dispute you've seen, there is a judgment of the Supreme Court and the country has taken it it completely peacefully. It is not that the judgment has been accepted because of the 1991 Act. If you see, the 1991 Act only has a passing reference.
Sir, I want to understand why, on what legal grounds do you think that 1947 15th August, that's what the Places of Worship Act essentially says, and I'm trying to break this down for our viewers. It says that whatever the situation was in 1947 15th August should stay the same. You can't ask to change it later, and they made an exception in that law for the Ayodhya site. Now, your contention is that this should be changed, that law was unfructuous, that act is wrong. So what do you suggest? How far back do you want to take this?
No, so I don't want, I'm not at all advocating of conversion of any place into from one religion to the other. But I also am of the view that rule of law is supreme in this country, and if anybody wants to contest a particular case, he should have a right to at least say whatever he has to say and then obtain a court verdict. Ultimately, whatever the court will decide will happen. Ultimately, if you see, what happened in Babri Masjid was not what court decided when the demolition happened in 1992. So that was something which was completely unacceptable. That should never happen. That kind of thing should never happen. But if there is a court process which takes a legal call that on the basis of the evidences that have been adduced, there is a predominantly existence of a temple before the mosque was, it was first desegregated and a mosque was constructed. I don't understand why the court process will create communal harmony. I mean, there is no logic in this. Unless if the government felt that if they had not brought in this law, all this forced conversion would happen, like it happened in the Badburi Masjid, demolition and all that.
Let me bring
Mr. Arjun in.
Let me bring Mr. Arjun in. So ultimately, is this going to come down to the relook or the demand for a relook of the 1991 Places of Worship Act? Is that the bone of contention? Because what we're also seeing is, in sense, a domino effect. A lot of demands being made at different sites right now. There is a case now in Mathura. There is a demand made on the Taj. There are social media posts talking about Qutub Minar. I mean, not all of these are in court at different stages. Some are just demands right now, but is that the concern?
And Tamanna, frankly, where do these demands end? Tomorrow they'll say so-and-so temple is made on a Buddha Vihara, or so-and-so, the Buddha Vihara is made on some older tribal religious place of worship. We have to understand that the Supreme Court has held that this Places of Worship Act is essential for secularism. In fact, the court has gone on to say that you cannot remedy historical wrongs like that. And my friend, Mr. Vikas Singh, he's the petitioner's counsel, so he has an argument that it's unconstitutional. I must tell him, he's much more older to me, so I must remind him that the concurrent list says that religious institutions are within the concurrent list, and the central government therefore has primacy on those issues. So therefore, it is a completely valid act. A 5-judge bench has in fact said this is a part of essential basic features that if you make. And as you said, there could be a dispute. You don't know. You go back 1,000 years. You go back 2,000 years. Where will this stop? You have to put this behind you. And I would just want to read what the 5-judge bench said. It says historical wrongs cannot be remedied by people taking the law in their own hands. In preserving the character of places of public worship, Parliament has mandated in no uncertain terms that history and its wrongs shall not be used as instruments to oppress the present and the future. So let's look ahead.
Let me ask Mr. Singh about it. Let's close with his comment and the point I made about concerns of a domino effect. If this goes through, because after Ayodhya and the Ayodhya verdict, the word then was that this is it and no more. Now you have Gyanvapi, there might be others coming in. Does this concern you, or do you think now each case deserves to be looked at in its individual right?
Well, Tamanna, I am not looking at the law and order issue or what my friend is trying to, make out as if there is going to be a, communal violence, etc. What he said is a contradiction in terms. He says that people will take the law into their own hands. Who is saying that people should be allowed to take the law into their own hands? The only point that is being made is let the judicial process go on. Why are you stopping the judicial process? And a judicial process can never say that a law is being taken in their own hands. Because if a judge is deciding one way or the other, it's not that people are taking the law in their own hands. So I don't understand. This is a complete contradiction in what he's saying. Because and secondly, in the Constitution bench judgment, nobody questioned the virus of the 1991 Act. There is not a whisper about whether the 1991 Act is valid or not. They just made a passing reference that there is a 1991 Act, and they also said that this. So what they have actually deprecated is the demolition. Who is saying that demolition should happen like this without the judicial process? Nobody is claiming that.
All right.
The demolition should never happen, and if at all there is a decree in favor of somebody, that decree should be executed like any other decree is executed. I am today dispossessed of my property, I get a decree, I get it back. So where is the question of any violence or any forceful
so this is what has happened. So in a sense, what you're describing it as, Mr. Singh, is a title deed. You're talking about property and right over property. But when you mix it with religion, it takes on a very different tone and tenor where all of these sensitivities come in. But I will end here. I want to thank both Mr. Vikas Singh and both Mr. Arjun Shuran for coming in and explaining and putting in their differing points of view in a way that hopefully enlightens our viewers who have tuned in. So for that, I thank you. And of course, we'll be tracking this case closely. Thank you so much.